All right, good evening, everyone. Welcome. My name is Rebecca, and I'm an event planner with the Orange County Library System. Welcome to tonight's virtual event, Ask a Lawyer, presented by the Orange County Bar Association. In tonight's event, you will have the opportunity to speak with a panel of attorneys to get insight and guidance on family law. Before we begin, I would like to share a couple things about Zoom. Please keep in mind everyone's videos besides our speakers will be turned off. You will be muted unless you're asking a question, and then you may unmute yourself. If you have a question and would like to speak, please use the raise your hand feature located at the bottom of your screen. And if you click on the reactions button, you'll see the raise your hand feature. Also at the bottom of your screen, you will see a chat feature. Please feel free to open that up. We will be putting an order of attendees who will be speaking. There'll be a list in the chat, and that's how we will know whose turn it is next. Please respect others and wait to be called on. We want to avoid people speaking out unless it is your turn. If you speak out of a turn, you will be muted. For those of you who are calling in on a phone, if you want to speak, you can press your unmute button and we'll see it and we'll add you to the numbered list. And we'll actually call out the numbers so that, or the last four of the numbers so that you know that we're speaking to you, and then you can speak. Without further ado, I would like to begin tonight by introducing Zeffery Mims, our moderator for tonight's event. Thank you so much for joining us tonight. I'm going to go ahead and turn it over to you.
Thank you, Rebecca. Good evening. My name is Zeffery Mims of Zeffery Mims Law PLLC, and I'm a member of the Orange County Bar Association. I'd like to thank you for attending our Ask a Lawyer event sponsored by the Orange County Bar Association and the Orange County Clerk of Courts. Before we get started, allow me to give you a little background about the Orange County Bar. The association has been around for 85 years. And in addition to serving the needs of our members, one of our goals has been to reach out into the community and provide services and programs that will benefit Central Floridians. Some of those programs include our members' pro bono work with the Legal Aid Society of the Orange County Bar Association, our lawyer referral and information service, our Law Week program for school children of Orange County, and our free citizen dispute and family law mediation program. The citizen dispute and family law mediations are facilitated by an impartial professional mediator who listens to both parties and encourages a resolution that is satisfactory to both parties. This is a free program for anyone residing in Orange County. Tonight's Ask a Lawyer event is just one of those programs, and we hope you feel free to ask any questions you have about family law. Orange County Bar Attorney Camy Schwam-Wilcox of Schwam-Wilcox and Associates and myself will help guide you through some of the issues that you want to know about. Tonight's event will be recorded and shared on the Orange County Bar Association's Facebook page. Please be sure to like the page if you're on Facebook. I'd now like to introduce Ebony Wiggins, the Operations Support Coordinator, to speak to you about the Orange County Self-Help Center. Thank you. Ebony.
Hey everyone. Again, my name is Ebony Wiggins and I am the support coordinator for the Self-Help Center. And I am here to present a PowerPoint of services provided at the Self-Help Center. So please allow me a minute to share my screen here. The Self-Help Center first opened its doors in 2015 to provide legal assistance for underserved customers who don't have legal representation. Our attorney consultations are virtual. We're located at the Courthouse Suite 340, and that's on the 3rd floor. The center is open Monday through Friday from 7:30 a.m. to 4:00 p.m. The types of cases that we provide services with in the Self-Help Center is family law cases, excluding injunctions, small claims cases, and residential eviction cases only. Our Self-Help Center provides virtual attorney consultations. You can also purchase forms and notary and copy services. We also provide landlord-tenant guidance, and computers are available for court-related business. Our attorney consultations are virtual. Appointments can be made online with a credit card. That does include a $1.50 convenience fee. You can also make your appointments in person in room 340 and have to be paid in cash. Attorney appointments are $1 a minute in 15-minute increments up to 60 minutes per day. And again, they're available Monday, Tuesday, Wednesday, and Friday. And you will also receive an email to attend a virtual appointment with the attorney once you book your appointment. You can, if you have any questions about the Self-Help Center, you can reach us at myorangeclerk.com. Press the Self-Help Center tab and click on the Contact Self-Help Center button, or you can call us directly at 407-836-6300, or you can also visit us in person where you can see my face. We're located at the 425 North Orange Avenue, room 340, and we're open Monday through Friday from 7:30 a.m. to 4:00 p.m. And I'll be here if you have any questions about the Self-Help Center. Thank you guys for joining us tonight.
Thank you, Ebony. At this time, I will open the floor for questions regarding family law.
And Zeffery, sorry, I just wanted to mention that Michael is here. Attorney Michael is here with us.
Attorney Michael Ferrin of Anderson and Ferrin, attorneys at Law PA, has joined us, and he's going to be also, in addition to Camy Schwam-Wilcox, answering your questions. Thank you, Rebecca.
All right, we're going to open it to questions. And so we have a list in the chat. And sorry, I just want to remind, because we do have a couple of people asking, you can either raise your hand and I'm going to add you to the chat. So if you want to make sure that your chat is open so that you can see that I put you in the chat. And also at the bottom of your screen where the reactions button is, that is where you can raise your hand. I'm also going to have, sorry, we can go ahead and get started. The first person is Teresa W.
Hello. Are you able to hear me?
Yes.
Okay, hi. I have a question about custody by extended family member. I know it stays open, and it still says pending, but there's been, when I go like to schools, I have the court order of the final order. I have custody of my grandchildren. And when it comes to school sometime or other legal things that's being handled for her, they say, oh, it's still pending, or they should have given it a deadline to how long this is. And I try to explain to them, that's not how it works. It only changes if we go back to court and the courts change it. So how do I make it where it's schools and doctors and other legal, financial things I can handle for them, that they're not asking me, say, it's still open, it's still pending, so that's not a court order, or they have the name spelled wrong and I got to go through so much to rechange it.
That's a great question, Teresa. Camy or Michael, you want me to take a crack at it, or you guys want to go first? Got some familiarity with this area.
I think you need to take it because I had a hard time understanding her. She was very muffled. I know it's about a temporary custody case, but I couldn't hear the facts. So
It sounds like the scope of the temporary custody isn't sufficient for her to like do things at the fill out forms on behalf of the children at school and doctor's offices. So I'd recommend definitely, Teresa, getting the court order. You would probably need to go back to court to get the scope clarified, because typically there's always an order that the judge issues regarding the scope of a custody by an extended family member. And so I would certainly start there, because you should certainly be able to, without being a guardian, say sign forms, permission slips, taking the doctor's appointments. So if your case is pending, I would certainly contact an attorney for sure, so you can get that help that you need.
Okay, thank you. I actually tried that, but one other, I guess, session I was in, a judge at that time was telling me that's how it is and that's how it stays. And I said, I guess, but it, like I said, it does say in this stipulation, I can put her in school. I could take her to doctors. I can take her out of county, just like a parent would, or if I need to do financial. But when I actually tried to use the papers, they say, no, I can't. And I have written many requests to the court, and they've It's been over 2 years and never no answer.
I would contact the Clerk of Court's Self-Help Center. They do family law, and this is family law probate-ish, so this certainly should qualify. I would certainly contact the Self-Help Center so that an attorney can review your case file, because I would imagine the answer lies somewhere there. So certainly contact the Self-Help Center for a consultation.
Thank you.
Oh, you're very welcome.
All right, and the second person is Kelly.
Hi, thank you so much. This is Kelly. I appreciate everybody's time tonight. Hopefully you can hear me.
Yes.
I had a question. Great. My divorce was finalized about 2 years ago. And during the proceedings and everything that we did in our paperwork, my ex-spouse was supposed to pay me directly for child support and alimony. But since about November of 2022, he has not been making his direct payments to me. He either has some type of excuse, he doesn't have the money, it's always just something, and it's me trying to grind and grind. And at this point right now, he owes me over $2,000 in child support and alimony. And I'm just not sure legally what I'm capable or allowed to do. Like, do I have to redo my whole divorce proceedings? I'm not sure what to do, because I need the money to support our child.
Okay, I would definitely, Kelly, recommend filing like a motion for contempt. You don't have to redo your divorce, so that's good news. You're seeking essentially to enforce the terms of the final judgment of dissolution. So in this case, it should be a pretty simple one-page motion for contempt, and attach the final judgment that says the former husband isn't doing A, B, or C. And the court should retain jurisdiction to enforce whatever it is the judge ordered regarding child support and alimony. So that judgment is enforceable, and a motion for contempt is the avenue. So certainly contact the Self-Help Center. They have a family law division, and you can actually get assistance filing the motion for contempt and serving your former husband. So it's a much streamlined process.
And also I was going to add too, is if your husband's a W-2 employee, what you can do is when you do the motion for contempt, you can ask the court to then implement an income withholding order. And that way the payments from that point forward will be deducted directly from his wages, and you don't have to wait for him or coax him to make the payment. It's going to come directly out of his wages every month like clockwork.
Yes, definitely.
Oh, that's great. That's very good knowledge to know. So I don't have to wait. Yes, because I'm trying to be as civil as possible. And that's why I'm kind of I've been civil, but at this point, when you owe so much and I desperately need the money to support our child for all her needs. And so all this information is on that website, the Orange Clerk of Courts, and then go to the Self-Help Center in there.
Yes, ma'am.
Okay,
And also
thank you so much.
if you decide that you want to retain, if you needed to get an attorney and you felt more comfortable getting an attorney, a lot of times when we do motions for contempt, the court will usually grant fees for having to bring the motion for contempt. So a lot of times the opposing party will have to pay your fees for having to do that.
Oh, that's good to know. That's awesome. Thank you so much.
No problem.
All right, the next person in line is Frank. Frank, you can unmute there.
Yes, I just did. Thank you. My question is regarding domestic partnerships and having to file for bankruptcy. Where is the best place to find information about that kind of proceedings?
So I think the fact that it's a domestic partnership doesn't matter.
Well, everything that I've read talks about marriages. Why? Is it considered the same, or is there a different set of guidelines?
Well, you would just not be able to file a joint bankruptcy. Either one of you can file bankruptcy, but if it's not a legal marriage, then it would be an individual bankruptcy, not joint. So if you both needed to file bankruptcy, you would file 2 individual petitions.
Okay, so just treat this as an individual.
Yes.
Okay, even though there's the same name, or the names are on the mortgage and the deed.
Correct. in bankruptcy court, which I know this is not about bankruptcy, I just happen to practice bankruptcy, so I'm able to answer the question. But in bankruptcy court, you can only file joint if you're a married couple. So there are a lot of people that are dating, or mother and daughter, relatives that couldn't get married that have to file bankruptcy because they own property together or they have debt together, but they don't get the benefit of filing one petition. You have to pay 2 filing fees and things like that. So it's 2 separate petitions, and anything that gets discharged, as long as it's dischargeable on the other things, they'll both get equal treatment.
Gotcha. Thank you very much. That makes it a lot easier.
Hello, this is Amber speaking.
Hi, so you'll be number 14, Amber. So next we have Joe. Joe, if you want to unmute yourself.
Good evening. How you doing?
Good, good. Good evening.
How you doing, sir? Okay. I got a question. I got divorced about, I would say probably 12 years ago. And I got 2 daughters. One of my daughters are already in university. And I got my youngest daughter, she's 13 years old. When we got divorced, we never put the house, right? And the owner who buy the house, and my ex-wife, she was my co-signer. My question is, when my daughter gets 18 years old, can I sell the house, or she needs to sign a paper or anything like that?
Well, it depends. If it's marital property, it should have been included in your dissolution. And some of the other attorneys can back me up on that. And if not, then it's like a business relationship or partnership. So whoever's on the deed obviously would be able to sell the home, subject to mortgage, which you would obviously have to pay off. But I guess the question is whether it's marital property at the time of dissolution. If not, then you should be able to sell it.
So actually, once the dissolution happens, the tenants in the entirety will automatically change to either tenants in common or joint tenants. And so it depends on what the title says, because if it's with survivorship, then, tenants in common, then you can't sell it because you can only sell your half. Actually, either one of those, you can't sell it because you can only sell your half. It all depends on, if somebody dies, does it go to your heirs or does it go to the other owner? So it looks like you're going to have a hard time selling that property if she's on the title.
Well, that was my question. I don't know if how you call this? Sorry. The co-signer is like the owner when you buy a house.
So the mortgage and the deed are one and the same, but separate documents. The mortgage attaches to the property, and the deed dictates who owns it. So the mortgage is a financial responsibility. The deed is an ownership interest. So just like Mrs. Schwam-Wilcox was saying, if it has gone from a tenants into the entirety to something where each of you has a survivorship interest that can go to, say, whoever you should designate, you would need the other person's permission to sell it if it's, say, a 50-50 joint ownership.
Okay, I understand. Okay.
All right, yes,
Okay.
what you might want to do, you might want to try and speak to an attorney that practices in real estate law, because more than likely what will happen is depending on how it's titled, if you can't sell it on your own, you may need to file an action for what's called partition. And through the action of partition, the court can then take, if the property, you have to file the case wherever the property is located. So if it's in the county, whatever county the property's in. So if it's Orange County, you'd file the case in Orange County, and you'd file an action for partition to ask the court to determine the rights of the parties and then order the liquidation or the sale of property through partition. That's an action that, again, normally you would want to retain a real estate attorney to help you with. They may also, depending on how it's titled, may also have other remedies for you, but that's for another day, I suppose. So.
Okay, thank you.
No problem.
Okay, thank you very much. I appreciate it.
Thank you. Our next person in line is Alyssa. Feel free to go ahead and unmute yourself.
Hello,
Hello.
good evening. Yes, I have a question about wills. So I heard that you can look up a will once it's been published or what have you. I don't know the correct term. But after someone has passed away and then the people have seen it, they said you should be able to see it. So I wanted to find out how to do that.
So that's a probate question. I don't know anything about probate. I don't know about the rest of the panel. That's
For tonight's event, we're going to keep it to family law only. Sorry about that.
Oh, well, this is for my family. It's for my adopted daughter. So I'm trying to find out for her. So when her mom passed when she was little,
so
and
family
then
law.
there was a
doesn't mean-
will.
Family law doesn't mean that it's a family issue. Unfortunately, family law means that it has to do
Oh.
with child support, alimony, time sharing, equitable distribution. So although it's a family-based issue, it's still a probate case. And our panel doesn't practice in probate, unfortunately. So I don't think we can answer your question. I'm sorry.
Okay, well then I have one more question, if that's okay. It's about also then getting her adopted family info. It took me a long time to speak to Georgia, but I finally spoke to someone and they said I have to go to court to get the form. She has to go to court to get the form in order to release the information about her family.
So that's an adoption court. It all depends. I don't know when the adoption was. And some adoptions are open and some adoptions are closed. So if it was a closed adoption, she doesn't get to find out any of the private information about her birth parents. If it's an open adoption, then there are motions that need to be filed in adoption court, which is domestic court, where you can obtain that information.
So do I have to get a lawyer? Does she have to get a lawyer or can I go down to the clerk of courts?
I'm not sure that the help center deals with adoption. It's a very unique area of law. You're never required to hire an attorney. That's not you don't have to, but it's always in your best interest to hire an attorney for issues that are especially complicated, which this would be, because of all the stealing that happens and intentionally trying to hide information in adoption cases. So I would recommend that you get an attorney to assist. Yes.
And our self-help center attorneys do not help with adoptions.
Okay, so who would I call?
So I'm
Where
gonna
would I go?
sorry, I just want to jump on to, for those of you who have questions, I'm also going to be sending you all an email after this is over with information on the loyal referral service and information service. So you're going to get an email, sorry, not an email, a website, a phone number, and also information on the Clerk Self-Help Center. So I'm going to put it in the chat, but you'll also get an email about this as well, where you can request a consultation.
Thank you, Rebecca. Yes, anything that's not covered by the Self-Help Center, the Lawyer Referral Service sponsored by the Orange County Bar Association can certainly refer you to an adoption specialist or any other type of attorney that you would like. Thank you.
Thank you.
All right, our next person in line is Lisa Sherbine. If you want to go ahead and mute yourself.
Can you hear me?
Yes, yes. Good evening.
Okay, good evening. I think you answered my question already, but my daughter bought a house with her fiance, and now they are no longer together. She has been paying the mortgage since he left in September. We were going to refinance, but she's got a beautiful interest rate and her payments would triple if we refinance. So I think you said that I should try to get a partition agreement through a real estate attorney and try to separate the two of them that way. She wants to get possession of the house without refinancing.
Yes.
Because he wants to move on.
Okay. I believe, yeah, petition, an action to partition would certainly allow the court to intervene and obtain jurisdiction to try to come up with some sort of novel solution, a payment plan of some sort, so she doesn't have to refinance it in such a high market. Definitely.
Is something like that really possible for somebody that's not married?
If they're both on the mortgage right now, refinancing with just a single individual would certainly change things. I'm not a banker, however, I believe a real estate attorney and in contacting the Orange County's Law Referral and Information Service, they can hook you up with a specialized real estate attorney that can answer that question better. And obviously it would also be dependent on the bank.
Okay, you were fantastic. Thank you so much for the event.
Yes, ma'am. Thank you.
Thank you so much. I'm going to ask the next question as it is anonymous. So my dad is living at a home and his mental state of being is deteriorating more and more each day. I received a pre-eviction notice and need to know how to proceed. Is this matter for family law?
So again, I think that there's a little confusion about if there's an issue that relates to my family, that it's family law, and it's not. So I think we, instead of calling it family law, maybe we need to call it domestic
Relations.
relations. Thank you, Michael.
No problem.
Because you know, it's a lot of things deal with family members, but that doesn't make it family law. And so although we would love to help, the three of us are not barred, or not, I shouldn't say that, the three of us don't practice is what I mean. And a lot of the areas that theme that it would be a family question. So unfortunately, I can't answer that. I don't know if Michael or Zeffery practice in that area.
No, I think I practice pretty much in the areas you do. So I have like bankruptcy, adoption, and family. So that's fine.
And criminal, yeah, then we're out.
Yeah, and criminal, and that's it.
Yeah. Thank you, Camy, for explaining that. And for those of you who still have a question, if you have a question that is not family law, we're so sorry, we're not going to be able to answer that tonight, but we will give you information of how to request a consultation through the lawyer referral and information service. So please be on the lookout for that email today. Although I did drop some of the links in the chat if you're interested in that. We're going to keep going with the next person in line is Thomas. If you want to go ahead and unmute yourself, Thomas. Thomas, are you there? I don't hear anything. I see that you're unmuted.
I believe Thomas was having connectivity issues. He was logging back in a couple times, so hopefully we'll be able to connect soon.
Okay. Thomas, if you want to type out your question, we can go to the next person and then come back to you if you want to type out your question to us. So the next person is Jill. Jill, if you want to unmute yourself.
Okay, thank you very much. Hello.
Hi.
Okay, good. All right, my question is, I'm being victimized by a Munchausen syndrome by proxy perpetrator who is a family member. Is this a family law matter, or who would I see to begin to develop a legal strategy to extract myself from this person?
Sounds like,
Go ahead, Zeffery.
well, I was just going to say, it sounds like consumer law, potentially breach of some sort of fiduciary duty or confidential relationship.
No, Munchausen is a form of
It's a mental health issue.
So it could either be I don't know, we need more of the facts, but it could either be in, you know, a Baker Act type of situation or an injunction. If you're trying to protect yourself from being the victim of a Munchausen person, then you might need to get an injunction, and it could also be criminal, depending upon how far it goes. Would you agree, Michael?
Yes, I agree.
When I read about it in the literature, it indicates that Munchausen syndrome by proxy is against the law.
Yeah.
What law are they referring to?
Well, it's abuse.
Right.
It's battery.
So it would be laws against abuse.
I mean, can you explain?
It just depends on what they're doing.
Right. that's-
So some things that they do would be considered a battery, which would be considered criminal. It could also, you have a lesser bar to meet, but you can try and file an injunction if it's doing something that would rise to the level of domestic violence or some other type of parameters that fall under the different types of injunctions that exist. So it just depends on the situation.
Okay, so what would you suggest would be the next step for me to investigate? What would be an appropriate way to proceed?
I think that you have a lot of different options and they're mutually exclusive. So there can be multiple, there could be an injunction in a criminal case. There might even be some type of civil tort. You probably need to contact the Orange County Bar Association that they'll send you later and get a lawyer referral to really dive deep and ask all of the questions.
Okay, thank you.
You're welcome.
Thank you. Our next question is going to be from Scott. Scott, if you want to unmute yourself.
Okay. Do you hear me?
Yes.
Hey there. Yeah, mine's about a divorce that I just recently had. It was fun. I don't understand. I got an email that says I have a motion for contempt that her attorney that she was using and telling me that I'm in contempt for 1,600 whatever. It doesn't matter, I guess. But it doesn't say why I'm in contempt. And so I don't know what to do. I mean, before I don't, because I represented myself. I thought it was going to be an easy matter, but anyway. So I don't know. I can call that attorney and speak to them and ask them, you know, what is this? Because it honestly, it doesn't say. It just says I failed to pay this money pursuant to the, you know, the recommended, because we went in front of a magistrate, so then got to the judge, and then it's, you know, final recommendation, right? Well, I have that, and there's nothing in there that says this amount of money that is owed to her. I mean, I know I'm paying arrearage, and that's what assuming that's what it's trying to say, or maybe it's what it's saying, but I can't come up with any number, you know, how they come up with that number. So I don't know what I should do, how I should proceed. Because she's been being paid ever since it happened, like you all were talking about earlier. It's being, you know, garnished out of my wages. So she's been being paid since it happened. So
when was your order? When was this most recent order entered?
The 18th, I believe. The 17th of this month, they filed a motion for contempt. But like I said, it doesn't say. It just, I mean, I can read it, you know, exactly what it says in that paragraph, if you'd like me to, but I'm not understanding what they're wanting or why.
If there's an issue with the order that either it's unclear or you think that there's some sort of error that the court may have committed when it submitted when it did the hearing, whether it was you didn't receive notice or they miscalculated the numbers or something like that, you can try and file a motion for rehearing. You're within the time frame to still do that. You have 10 days from the issuance of the order to file a motion for rehearing. So you can try and do that. I'd say probably take a look and see if that's an option for you, but you're definitely under the gun. You got to make sure you get it filed in time.
Okay. Motion of rehearing?
Yes.
Right. Okay. So yeah, I guess I could probably print it off the help section and then
the self-help center can help you with that. And sometimes I think the clerk may have a form for that. I'm not quite sure, but definitely contact the self-help center. They can definitely help you out.
Okay. And so then when I go though, I guess we have a hearing. I mean, I don't know. I mean, but okay, actually I was asking, I mean, I guess since I represented myself, I'm allowed to call this attorney's office and speak to them, or is that not recommended?
No, you can talk to them.
Yeah. To ask them maybe why or where they're coming up with this, you know.
Well, they
so
can't
can
give
get
you legal
resolved.
advice because they don't represent you. They can't give you legal
Right.
advice. So if you're looking for clarification on stuff, opposing counsel may not be the best source. But yeah,
Right.
yeah. But like I said, I
Okay.
mean, the clerk is there to help. They have the self-help center. And you can
Right.
try and reach out to opposing counsel, depending on what you're asking of them. They may be able to also clarify some things.
Right. Yeah. Would you guys know any? Because I know she's got help from legal aid, and I know they won't help me. So, but I did go on and found like, you know, community. I guess like attorneys have to do pro bono work to help, you know, for your whatever, I guess, continuing education. Well, that's what she had. You know, he was doing his pro bono work, and I called this community local from Orlando. And first I was told, yes, they would help me. And then an attorney got on and asked me, you know, who her attorney was. And they said, well, they couldn't do it as a conflict of interest. I kind of didn't understand that, because to me, you know, there's how many thousands of attorneys. How could that one little attorney's office be a conflict with a whole community organization that, you know, that helps attorneys do their pro bono work? I didn't understand that. The guy did that, then hung up. So I don't know if you guys know, or like you're saying, I guess, you know, you could, I know it's in Seminole County, and they told me too, they have a thing where you can do with an attorney for $1 a minute type thing. So I guess maybe I'll do that and try to see. But anyway, okay. Yeah, I'll do the motion for rehearing. You're saying that's what I should do, and then go from there. And I guess I the court just asked them to explain it or show me or whatever, because I'm sure they'll make a court date, correct?
Yeah, you'll receive notice of the court date for the motion for contempt, and you could even file a response that kind of at least memorializes your position. But you would certainly be able to seek guidance from the self-help center. You could get a more detailed consult, and you could even send the contempt motion to the attorney so they could review it. And if you want to hire an attorney, you can contact me.
Yeah.
On bar,
Yeah.
the lawyer referral service.
Okay. All right. Thank y'all for your help. I appreciate it.
Thank you, sir.
Have a good evening.
Thank you so much. Okay, we're going to swing it right back around to Vanessa really quickly, so she could clarify a previous question about family law. So Vanessa, if you want to unmute yourself. Okay, I'm going to read the question from the chat and let me know if this is family law. My late mom left a will with me as the executrix. My younger sister fraudulently sought out a lawyer with a fake will and was able to have that lawyer put property in her dad's name that was left to my brother in the will. I have received a pre-eviction notice from him, but I've been paying the mortgage on his property prior to my mom's passing. I feel like that might be real estate or something else.
It's probate.
It's probate. Yeah,
Sorry.
it's probate.
Sorry, Vanessa, that question is not family law. Okay, we're gonna go on to the next person's question. Sorry, let me scroll back up. Patricia Gonzalez. If you want to unmute yourself, Patricia.
Thank you. Hi, good afternoon. Thank you for your service. That's awesome that you guys are educating us, because we are clueless, or at least I am, of everything about law. I would like to know if you guys can do a trust or a will.
Again, that's, believe it or not, that's probate.
Is it? Okay. Another question, can I? Is that okay?
Yeah, of course.
All right, thank you so much. I'm also had applied for SSI due to my disability. And it seems to be that they keep declining for some reason. I haven't been able to work, and I have to resign from my job due to my illness. After COVID, my lungs got really messed up, and I'm in oxygen 24/7 now for the rest of my life. And they keep telling me that I'm not able to get SSI. And my doctors, nurses, family members, everybody has advised me to do, to do that. But I'm being declined all the time for disability.
That sounds like administrative law. And I know the lawyer referral service for the Orange County Bar has an administrative law panel. So I would certainly contact them regarding that issue, and they can get you an administrative law attorney. But I believe that's administrative law.
Administrator law?
It's essentially, yes, ma'am. You're dealing with like a government administration, kind of like the VA. You make a claim and the decision is something that can be reviewed. Something an administrative attorney should be able to help you with. So I would certainly reach out to the lawyer referral service for an administrative attorney. Administrative law.
All right, thank you. And you wouldn't happen to have that number, or should I
Yes,
just look in the?
so for the lawyer referral and information service, I'm going to be sending you guys an email after this event is over with the website, the phone number for both the Loyal Referral and Information Service and the Clerk Self-Help Center. So you will get all that information in the email.
All right, thank you so much. And can I take advantage of you guys and make another question if it's possible? Even though it's not
family
for me?
law?
I do believe so. My daughter was with her husband, kind of. I said kind of because they never got married, but they lived together for 10 years, almost 12 years. And they bought a house, even though that he put the house on his name. But that's been sold by him and everything, and she was living with me. She's not right now, but since they separated, he has not give her anything to support her kids. They have 2 kids. And she hasn't do anything neither, because she said that it's up to him to give it to her and for the kids. And she's working like 2 jobs to support the kids.
It sounds
And
like
yes, because they're not married, so she goes like, well, because we're not married, I'm not supposed to say anything about it, because I mean, I'm like, yeah, but you left with him, you lived with him for more than 10 years, and the house was paid by you both. Everything was paid by you both. And then suddenly he just took off, sold the house, kicked her out. Well, he didn't kick her out. She left the house because he was gonna sell it. And but the kids are, he calls them and everything, but he doesn't send no money for her or for the kids, I mean.
Okay, it sounds like a paternity case, and that is family law. So you can certainly file a petition to establish paternity, which essentially is the court acknowledging him as the father, and child support, time sharing, parental responsibility. Those are all things that fall under the paternity umbrella. So although they weren't married, the fact that they had children certainly requires an establishment of paternity, and that's when child support and some of the things you were discussing that she's going without right now, he can catch up and kind of help her. But certainly contact either the lawyer referral service or the self-help center for a family law referral, so you can have a consultation, because she can certainly file a paternity case to clarify some of their relationship regarding their children.
Okay. Yeah, because one of them is autistic, and he just, I guess he got terrified and just left. And in the other hand, my son is paying $2,500 for child support, and he doesn't have anything left to pay anything else, nothing else, because the judge told them that he has to pay $2,500. They had 4 kids. They were married. They got divorced about 2 years ago, but he is paying $2,500, which I think for myself is way too much, because he doesn't know how to. He doesn't have any other money to spend to pay anything else. Nothing. I mean, he just stays with maybe $20, $25 for him, and the rest is for her. And not only that, he pays after school for all 4 kids as well.
Okay, well, those, the child support's predicated on the net income of both parents plus the distribution of overnight. So certainly contact the self-help center and get a family law attorney. It'll be a consultation that will add a lot of clarity, but that all can certainly be addressed with a petition to establish paternity.
Petition to establish paternity. Okay,
Yes.
petition to establish paternity.
And if he's
Okay.
already been ordered to pay child support, it will be a supplemental petition. But yes, ma'am, family law referral will certainly clarify that. It could be a petition or supplemental to an order for child support.
Supplemental, you said?
Yes, ma'am. So if there is a child support order in place already and you're seeking modification based on if the payments are just too much in comparison to the income, there is a standard that must be met, a substantial change. And so a family law attorney will be able to help you file that petition in a way that would certainly be able to potentially get the child support adjusted.
So my son has to hire a lawyer?
It sounds like he may at least want a referral to make that decision once an attorney has had an opportunity to review his case file and what the final judgment of paternity requires. And if his income has changed substantially, then that's certainly grounds for a supplemental petition.
Okay. All right then. Thank you so much, you all. Thank you for your service and your time. Thank you. I appreciate that.
Thank you. Our next question is going to be from Chantel.
Hello, can you hear me?
Yes, good evening.
Okay. I filed for a divorce in December of 2018. It is still pending. I'm wanting to see if I could get advice on how I go about getting the judge that's on the case to rule on 3 outstanding motions, 2 of them being final judgment ruling for divorce because we had a trial a year and a half ago. I still have no ruling, and also have modification of child support motion pending from 2020. And then I also have contempt of child support, which the judge is not enforcing, from October of last year. And the motions are just being sat on, and I don't know what approach to take to enforce this child support. After numerous hearings, numerous conferences with the judge, we still aren't getting anything.
So as attorneys, we have that same frustration sometimes. Some of the judges just move faster than others, and you need to gently remind or request a final judgment from the judicial assistant for the trial. For the modification motion that you filed, that's not going to be heard because you don't file modifications by motion, it's by petition. So it wasn't done properly. So that's why the court is probably not addressing that. And for the non-payment of child support, the enforcement part, just like the person who asked earlier, you need to file a motion for contempt, but just filing the motions don't get you a hearing. You have to actually contact the judicial assistant and select hearing date before it'll be heard.
Chantel, did you get that?
Yes, can you hear me?
Yeah, now.
Yeah, we did have a hearing in regards to that, and it was a petition that was filed, not a motion for the modification. And it's been a year and a half, and some of them, the other one has been 3 years.
Yeah, that should not happen.
Right.
So you need to just gently request relief by contacting the judicial assistant or setting a status hearing. Depending upon who the judge is, some judges will allow you to set a status hearing. You could go before the court. Some of them will not. But
yeah, the judicial assistant has been contacted numerous times, and they keep telling us, give him a week, give him a week, give him a week. And that's been going on since September of last year. The judge has since left the district though and been reassigned to a different county. So our hands are tied not having access to the judge.
Well, hopefully you had a court reporter. Otherwise, there's a possibility that you're going to have your trial over again. So this is a case where there's a lot of red tape, unfortunately, and so you would probably benefit from hiring an attorney to assist you through the process, because this is a process issue.
You're saying restart the entire trial?
I'm hoping that that doesn't happen, but what I'm saying is you said the judge left the jurisdiction and you're waiting for a final judgment. Well, a new judge can't enter a final judgment
right
stipulated to. I mean, if there's no dispute about it, it will be fine. But it doesn't sound like this judge is moving forward and signing it either. So this is a tough issue. You might benefit from having legal counsel to help facilitate that process for you.
Okay, and to facilitate the process, you mean restarting or?
No, I mean finishing, getting your orders executed.
Okay, so what, is there something that needs to be filed that you can think of offhand that would?
Not without looking at all the documents, no, but definitely a status hearing to say what's happening. Why am I not divorced? Why am I not getting my orders? What am I not doing right? For me to be able to answer that question, I would have to look at your whole court file.
Right.
You know,
Right. And we did have a hearing like that, or a conference, and he said, I'm almost done. And that was like 8 months ago. So, and I don't know, since he's out of the jurisdiction, how would he be able to wrap that up, or how would we even have access to, it's just left me hanging, and not enforcing child support either. I haven't received child support. It's court ordered in over a year.
You definitely need to have some type of legal assistance to facilitate the process for you. It sounds like you're not getting there's something missing. There's some break in the chain, and that needs to be looked at and fixed. Even if you just go to speak to somebody for some advice, showing them your file, they might be able to tell you your next steps. But it's not, what's happening should not be.
Okay, so is that something that you guys can help with?
Any family law attorney can help you with that.
Okay. I mean, because at this point I can't afford any counsel because I was $50,000 in legal fee debt because this has been going on forever. So that's why I was asking, is it something that you guys could assist with?
Well, another option as well is if you've been reaching out to the judicial assistant for that particular judge, you may also want to include the administrative judge. And I've found in the past when I've had that particular problem, it helps to let the administrative judge know that there's an issue with getting a timely order, and they'll do their best to help with the process and try and get that order issued as quickly as possible.
Yeah, and that route we went that route as well. So I just,
I think we've given you all the advice we could possibly give you on the subject. So
right. Okay, well, thank you.
Thank you.
Bye-bye.
All right, thank you. Our next question is coming from Cornish, who I don't think is in the meeting right now. So we are going to go to the next person. And let me just double check that I didn't miss somebody.
I'm here.
You are? Oh, wait, Cornish?
Yeah.
Okay, sure. Do you want to go ahead and ask your question?
My question is just simple. My attorney is like, not, he wants to just run away from the case. So I sued him, and now the summons is being served and he's not accepting the summons. He's just running away from there. Sheriff has been going to his office like every day, 10 days.
Yeah, it doesn't sound like it's a family law question. So I don't think we can answer that for you.
All right, bye-bye.
Thank you. Our next person in line is Amber. Amber, if you want to unmute yourself.
Hello. Hi, good evening.
Good evening.
Hi. My question is about missed child support from a father. he's going into a pattern of missing child support every few months and then goes into a payment plan of $100 added as an arrears. So I also have Florida Revenue Child Support active for myself. And they have some enforcement actions, but none of them is helping. The enforcement actions are, for example, not letting him renew the passport, which happens like after every few years. So that's not helping. And he owns, he's the owner of the gas station. So if they try to take the money from the pay stub, he decides how they come out. So that's not helping. Like there's other enforcement actions. They try to cancel his driver's license, but then he goes into a payment plan and then reactivates that. So he owes me like some $15,000 to $18,000 in child support. And recently he went into a payment plan again for $100. He didn't pay me for 3-4 months, and then he has just created a pattern like that. So that's one thing. And the other thing is we recently had a mediation order in which he was supposed to pay me attorney's fees. So he's violating that as well. He hasn't paid me for past 6 months of attorney's fees. That was already an installment. The total balance was like some $6,000, and now he hasn't paid me the $250 of the attorney fees that was in payments. So I do not know how to enforce that. Yeah. So what are my options? What do I do?
So they're both the same answer, which is good news. You have to file a motion for contempt. You can actually put 2 counts in the same motion and do one for the child support portion and one for the attorney fee portion. And if you hire an attorney, this would be another one of those cases where the court would likely order reimbursement of attorney's fees for you because he's not doing what he's previously been court ordered to do. Also, because he's self-employed, he probably, not every self-employed person takes a W-2 income as well as their profit distribution. If he does take W-2 income in addition to his profit distribution, then you would be able to get an IWO, which is an income withholding order. But it sounds like if you got that, he would just stop taking the W-2. So you may want to think of another creative solution regarding how the money could be withdrawn from him automatically, like through his bank or something like that, and see if you can get the court to order that.
Right, and when you do file the motion for contempt, there's another remedy that the court can do, which is called incarceration, which means we put him in jail. And if the court orders are not grabbing his attention, sometimes that will usually jar him to start making some payments. The court can actually order him to pay a purge, to kind of get out of jail free card, where he has to pay a certain amount of money to get out. And if his actions become severe enough to where he's purposely disregarding court orders after being held in contempt multiple times, you can raise it up a level and you can actually ask the court to hold him in criminal contempt, where he can actually put in jail for an extended period of time because of his actions. So, but those are all remedies that are available through contempt, depending on whether it's a coercive, where you're trying to get him to pay, or whether it's punishment for not paying. And so for those reasons, you may want to contact an attorney to try and help you out with that, because the success rate on contempt when you have an attorney does tend to get a little bit better when you have an attorney, because we know how to do it versus when you try it on your own. So you definitely want to look into that option. But again, the Self-Help Center does also offer help with that stuff as well.
I see. So do I have to come out of the Florida Revenue Agency plan to file the motion to contempt for this issue?
No. I mean, they obviously do their own enforcement proceedings and stuff. And if you want to continue to rely on them, you can, or you can hire private counsel to assist you with that.
Private counselor?
Counsel, like private attorneys, like me and Ms. Wilcox.
Right. So if I hire one of you, do I have to come out of the Florida Revenue Agency plan or no?
No.
No, I don't have to. No. Okay. So what did you say? What kind of motion it is?
Called a motion for contempt.
There was another term you used before, after motion for contempt.
think she's talking about incarceration, Michael.
Oh, and incarceration just means putting him in jail. It's just a fancy word for paying.
Is it that, I read about that online and they say if he does not pay 4 months consistently, only then that part is applicable on him, but he doesn't go 4 months, he is 2 months, 3 months, and then he goes into a payment plan. He's getting the payment plan from the Florida Revenue Agency. Basically, they have a plan if they cancel his driver's license and he goes back and do a payment plan.
They can suspend other professional licenses, not just his driver's license. So if he holds any other license with the state, so if he owns a gas station, he might have a license that he has to get to in order to be able to sell gas. They can suspend that license too. So
yeah, they never went into that enforcement. I'm divorced since 2017 and I have Florida Revenue Agency from 2018. Okay, so now this is a new order, like recently in 21, because he did a modification of child support after the COVID. So that's where our new mediation order was created. And when we finished the fight, he ended up to get the burden of the attorney's fees and he went into the installment. So in order to get that installment payment of the attorney's fees, I have to do motion to contempt for that as well.
yeah, anytime you want to enforce an order, the motion for contempt is how you would do it.
Okay, I have one more question, please. So part of that, the marital settlement agreement done in 2017 when we were divorcing, part of that MSA, he owed me some own during the marriage, and then we put it in the MSA. It was about some $45,000. The order says that he has, anytime the mother wants the payment, he has to pay me $600 installment out of that loan, and until the youngest child is 18. So in 2021, I enforced that. I filed a motion for contempt and he started the payments of $600 every month from that loan. That was part of initial marital settlement agreement. And now he also stopped paying that. What is the enforcement option for that?
So it depends on how the court determines what that is. So if it's property settlement, then you're going to have to seek action through your civil remedies, like through civil court, to file a motion or file a petition to enforce the order and basically collect like a debtor creditor situation. If it's an issue of support, so if it's alimony, something related to child support, things of that nature, then you can file a motion for contempt in the family case that you have. If there's anything that he is supposed to do, so like execute, so if he's supposed to sign paperwork or he's supposed to deliver something, things of that nature, the family court can still enforce that. But when it comes to the payment of money for division of property, unfortunately, the family court is not going to be able to help you in enforcing that. You would have to go and take your civil remedies through the civil court, just like a creditor would against somebody that owes them money.
Unless if her final judgment says that the court is going to retain, so we actually need to see.
Unless, yeah, she's right. Yeah, unless it says that.
So can I tell you what it says?
For today's purpose, it's a little bit difficult for us to be able to just give you advice on specific documents. We can talk in generalities.
I see.
But if you need assistance with that stuff, like I said, you can. A lot of attorneys in the area do offer free consultations. Some of them, if you're having them review paperwork, they'll usually require a fee to review the paperwork. Or like I said, you can contact the self-help center and they can review paperwork and help you out there.
I see. So Mr. Zeffery and yourself, Michael and Camy, all three of you, do you have a free consultation?
I do not.
I offer free consultations, but not in reviewing paperwork. For reviewing paperwork, I bill at $300 an hour.
Okay, but if it's not paperwork, like just to discuss the scenario and what could be done in the first talk, I can call you.
Again, it's very different. Even with consultations, it's very, very difficult to go into very, very specific information regarding your case, because usually a free consultation, at least with my office, I don't know how it is with you guys, but it's 15 minutes. So we kind of go over everything real quick, kind of get an understanding of what's going on in your case, and then we quote you a fee for what we can do for you. But if you want something very substantive where you want to talk about details of a particular agreement or order, usually that would require for most attorneys a paid fee for a consultation for that.
Okay, before I let you go, last question. So the child support in arrears, that's already in arrears, like some 12 to 13,000 from past is the total balance, and he's in the area for that $100 per month. So can I do anything can I challenge that part, or it's just going to be the motion for contempt is just going to be for the future payments that he missed before going into the arrears?
I don't think I understand your question, but I mean, if he's not paying something, so if he's not paying the contribution that he's supposed to be paying towards the arrears, or he's not paying the ongoing payment, whatever he's doing in violation of a court order, you can file a motion for contempt.
Okay. Okay. Thank you very much, everybody.
No problem.
All right, we have about 20 minutes left, so we're going to try to get through as many as we can. But the next person is Litsa. If you want to unmute yourself.
Yes, hi, good afternoon. Can you hear me?
Yes.
I'm sorry. Yes, my question is, I'm in the process of divorce, and we came with the other party with a settlement agreement. And we have 2 kids in a house, you know, and the settlement that we came is that, you know, I will give some money to him and I will keep the house. And, but my question is, I request to my lawyer who's representing me right now for her to do a quick claim deed. Can she do a quick claim deed for me? Or I have to get an attorney and a real estate attorney to do a quick claim deed?
Some attorneys do them and some don't. It all depends on who your family law attorney was or is, and if they know how to do it.
Oh, okay. And another question, prior to this attorney, this current attorney, I have called the barn, the Orange County Bar Associations to hire a lawyer to represent me when I was in my second mediation, which, you know, we came in agreement with the other attorney. But when we were in the second mediation with the other party's attorney, I asked, you know, this lawyer to, you know, what were the rights or the law for the other party to continue paying the bills and everything that he was paying when he was in the house. And it came to the point that the other attorney asked the attorney that I got from the Orange County Bar Association that he wanted to speak to him in private. So when he came back like 30 minutes later, and during the mediation, he came back to me and say, hey, I can't respond your question. In other words, he never responded the question, what was my rights or the law, you know, for the other party continue paying the bills. So in this case, I wanted to see what I can do, because this lawyer, it took the money that I pay him and he left me in red because he never got back to me and say, hey, you know, we have to discuss about, or because he never responded the question when I asked him what are the rights or what were the.
That's not really a family law question. You're talking about suing an attorney, not your actual case. So that's not something this panel can answer. Sorry.
Okay, thank you.
You're welcome.
All right, our next question is from Sherilyn. Sherilyn, if you want to unmute yourself.
Hi, I'm very appreciative of having this opportunity to ask my question. So my question is, if there's an ongoing situation in the home where one does not feel safe, what options? What legal options are there?
So you can get an injunction for protection.
I'm sorry, I didn't get that.
You can apply for an injunction against domestic violence if that is something you're concerned about. The court will review the facts and the allegations and either grant it without a hearing or schedule a hearing and give the opposing party an opportunity to be heard. Obviously, if you're in the same household, it complicates things a bit, but there are mechanisms in place. So if you contact a lawyer referral and information service or the self-help center, that is a domestic relations issue. If there is in fact some sort of threat within your home, you can seek an injunction for protection against that threat if it is imminent. So definitely contact, I would say, the self-help center. You can get a step-by-step guide on how to fill out the form and you can file it. And again, it's something that the court may grant without a hearing depending on the severity of the issue.
So I was also told that that the house would be sold, and I don't really know. I mean, the house is on both of our names. So
Okay.
I don't know if that is really, I mean, if he can really do that, if the house is on both our names and he's saying that, oh, he's just gonna sell the house and, you know.
If you both live there, like Schwam-Wilcox said, it's tenancy by the entirety. So both of you have to agree to any sale. So if you're both, again, living there as a married couple, it's married property that should be treated like joint ownership, wherein you both have to agree to sell or encumber for that matter. So, I mean, it sounds like you definitely have a family law issue that an attorney should be able to kind of walk you through. That's something that obviously I would recommend you contacting the self-help center. It's equitable distribution is something during dissolution of marriage that is addressed. So it's obvious you have marital property. So that's something that you are entitled to as the wife. And the number to the self-help center is in the chat. I would certainly start there if you'd like to, regarding just kind of the imminent threat and any future plans you might have to file.
Thank you. And we will be emailing that to you after the event as well.
Thank you.
Okay, we'll go to our next question. I'm gonna actually read this one out loud. I have, sorry, if you, sorry about that. What happens to assets when a spouse files for divorce? Husband works with assets outside of the state and wife is a stay-at-home with no prenuptial.
I'm not sure I understand that whole question, but I think if I get it right, she's asking about what her rights are and how she's going to get the marital portion of the assets, because she believes that maybe since she wasn't working and the husband paid for them through his work, that they would be his assets, but it doesn't matter. If you're married and the assets were accumulated during the marriage, then they're marital property, no matter whose name is assigned to it. So I think that was the question, but
Yes, it seems like that was. And then there's another part of that question. What is required to get a divorce? Are police reports for domestic violence, therapist visit notes, testimony from immediate family used?
could all of that can be used if there's ways to get it into evidence without it being hearsay. So sometimes you need the witnesses to come in. You can't just put in a police report. You would need the police officer to come testify about his or her observations and statements in the report, but there's ways around getting most things into evidence. Not everything is necessary to get into evidence to prove your case. And sometimes the testimony alone, which is considered evidence, is necessary in light or instead of the actual document. So there's really not a yes or no answer to that question.
Okay. And then the last part of that question is, when a wife files for divorce, can the wife leave the home if there are concerns of immediate danger? And would this be considered spousal abandonment?
She can leave the home. Florida does not recognize abandonment as it relates to property, specifically during the pendency of a divorce. So she still would be entitled to half of the marital value of that home.
All right, thank you so much for answering that question. Sorry, give me 1 second. The next question is, okay, so I've been a single mom of 13-year-old daughter since she was a baby. Me and her father were never married, and I never put him on child support. However, I've recently become fed up with his lack of financial support and recently filed for an application for child support. I'm at the beginning of this process, so we haven't had a hearing or anything yet, but I was wondering, how far back am I able to request back child support? An additional question is, he claims to only work a part-time job for $11 an hour. I make much more than that. Do you think he would still be required to pay child support given the income difference? And I can repeat any part of that you want.
Yeah, typically 2 years. If 2 years, the court will award retroactive child support. And it is predicated on the time sharing district. So although you make more than him, the fact that he had what sounds like 0 overnights would still maybe entitle you to certainly some back child support as well as ongoing future support. But 2 years is what the statute says regarding retroactive support when the parties were living in separate households.
Thank you. And we're going to go on to the next question from Eileen. Eileen, if you want to go ahead and unmute yourself.
Thank you. Yes, I am the caregiver to a 90-year-old father who has dementia and other medical issues. I have been the power of attorney and the fiduciary for veterans benefits since 2011, but I am interested in changing my responsibility from power of attorney to guardianship. So I have 3 questions.
Well,
One,
none of us are, we don't do guardianship work, unfortunately, so we're not gonna be able to answer your questions. So
oh, my apologies. I thought that was part of family law.
it's not, it's in probate court, believe it or not.
Okay, then I guess I'm all set. Thank you.
I'm so sorry.
No, it's all right.
Sorry about that. Okay, and okay, back to the previous question that we have another part to the question. If the wife does not work and the husband is the sole provider, what type of financial support can a wife get coming from a divorce? At what age does child support end?
Well, I guess so the age of child support ending is the age of 18 and not to exceed the age of 19 if they're attending high school or attending school in good faith. There are times, very specific situations where child support can exceed the age of 19, such as if the child is disabled, something along those lines. So that, I think, answers that question. With regards to the support, it depends. So it depends on the incomes of the parties, how long you guys have been married, the lifestyle lived during the marriage. There's a slew of factors the court considers when determining whether there should be alimony and what amount of alimony and how long the alimony should be paid. So there's a couple of main ones. So there's rehabilitative alimony, which is usually involving some sort of a rehabilitative plan, which would, like, for example, if you always wanted to be a nurse and you forewent being a nurse to go and raise your kids and be a stay-at-home mom, then you can ask the court and you have the plan to say, look, it's going to take me this long to become a nurse. I need this amount of money. And once I'm done, I'm going to make this amount of money. I'll be self-supporting. So I need a rehabilitative alimony. There's durational alimony, which is never to exceed the length of the marriage, and oftentimes is something less than the length of the marriage. You have bridge the gap, which is usually for very short-term marriages, usually to kind of help you transition to being single. And then you have permanent periodic alimony, and that's usually for marriages of long durations. Sometimes marriages in less than long durations, but very specific circumstances where the court can order that if it's less than a 17-year marriage. So again, it just depends on your situation, but depending on those factors, will depend on what kind of alimony and how much and how long. If you ever want to like look it up, if you just look up the statute, just Google Florida alimony statute and it'll pop up. And if you look at that, the factors are very easy to read. It's pretty self-explanatory of what factors the court considers, but there are quite a few of them to rattle off, but they do have quite a few there the court considers.
Okay, thank you so much. That was the last question that we had, and it's 6:53. So we have some closing announcements. First of all, I want to thank all of our attorneys and for Candace and for the Orange County the Orange County Bar Association, and also the Self-Help Center. Thank you so much for all the representatives who are here to answer all of our questions. We want to thank you so much for your time and for getting me through these questions and for all of your expertise. Thank you so much.
Thank you for having us.
Yeah, you're welcome.
And sorry, Zeffery, did you have any last minute?
Yeah, I just want to say thank you all for attending our Ask a Lawyer event. Please contact the Orange County Bar Association's Lawyer Referral and Information Service to be referred to an attorney for a free consultation for up to 30 minutes. And again, thank you all so much for attending, and have a great evening.
Thank you all so much. Please note that I will be sending an email after this event is over, and that's going to have all the information for the Loyal Referral Service Center and also the Self-Help Center. And also I'm going to add the Facebook page for the Orange County Bar Association so that you can also know where the recording will be and you can access that. Thank you all so much for your time. We hope that we answer some questions, and please note we will have future events as well. Thank you all so much for your time, and we hope to see you guys at a future event. Thank you.
Thank you, Rebecca.
Thank you.